As some of you know, one of the big debates when I speak to you is whether I'm going to sit or stand. But at my height, it really makes no difference. I think I come across about the same. It is so, I want to thank Ms. Danford, who was able to get me here. I started the day in Florida this morning, and to get here at 10 was a little bit dicey, and she did such a good job, and I appreciate it. And to Henry for including me, and most of all to you, the judges. There's nothing that I do in life, any talks or exchange of thoughts, that is more important than this. And some of you heard me say this, but I never forgot it, and I always mention his name. A gentleman named Harry Spencer, who was on the Supreme Court of Nebraska, when I was 32, gave me the first opportunity to talk with judges. And it was amazing and awesome. And I feel the same way now, it's many, many years later, to have that opportunity. And I've gotten feedback from you all over the years. I got emails, and I really value any thoughts you may have. Today, we're talking about emerging legal issues, and my outline is in your materials under emerging legal issues. And the focus is on duty. And it's interesting, all of you probably should obtain this as soon as it's out. The Restatement of Torts Third, the liability for personal injury and emotional harm, is likely to be approved at the American Law Institute's meeting on May 20th of this year. And I worked on the advisory committee for 6 years, and there was a lot of work on duty by great scholars, very balanced plaintiffs' lawyers, defense lawyers, but we became immersed in the topic, and I've thought about it a lot. I see 4 extensions going on, at least, on the edge in the pharmaceutical area. One of them, and I'm going to discuss each separately, is what is called Anti-Externalization Theory. This is the most sophisticated. I'll try to break it down in plain English. The second is duty to third parties against the conduct of persons who consume pharmaceuticals. The third is one that was so well discussed by Burton and Valerie, the duty of brand name pharmaceuticals for the wrongful acts of manufacturers of generic drugs. And finally, a point that was discussed the other day, but I'll embellish it a little bit, and that's the duty of warning a consumer of pharmaceutical products directly. Believe me, when I was a plaintiff's lawyer for 14 years, when they get together, they're smart, and they don't discuss these things always individually, but they look at the overall concept. If you can convince one of you judges to expand duty, that's not just one case, that's thousands of cases. That is the jackpot. That's American Idol win if you can change duty rules, because it changes the law forever and brings in a whole bunch of new and thousands of plaintiffs. My first question, and this is probably the most challenging, we have an article coming out on this in a journal a lot of you read, the Journal of Trial Advocacy, about anti-externalization of risk theory. And I owe this insight, I have to say, by collaterally. I was this very academic thing on restatement first. I mean, it was so academic, there was smoke there. And I was the last panelist, and I'm not that academic anymore, but they were all saying who inspired their law review articles. And they talk about Cardozo, some professors I never heard of. Well, this was inspired by Criminal, who taught me about this. He's Dickie Scruggs, he's a great man, serving time, and he taught me about this. He said, Victor, all of you people are running around under labels like nuisance, Consumer Protection Acts. You're not in the room when I speak to a state attorney general. And when I want to go after a drug company or an oil company, it's this simple. This is what I say. And that is that a company should not be permitted to externalize a risk, a cost it creates for society. And that should be borne by the company itself, and no externalization of risk. That's what I talk about when I have that 3 minutes with the AG. And that's what is used to convince him or her, if the political climate is right, to go after that particular defendant. Now, in the Restatement of Torts Third, which I've talked about, the core duty rule is that there is a liability if you fail to exercise reasonable care, and a failure to do so creates a risk, and the actor is responsible. Externalization theory is different. If a product or service can be showed in some way to have created a cost for society, the manufacturer should pay. All of you and everyone in this room know that this theory really began with tobacco, with Dickie Scruggs and others. The tobacco companies shouldn't be able to thrust on our society a Medicaid cost, and the company should bear it. And eventually there was a huge settlement, not a lot of case law, but the theory was the underlying theory of a lot of the cases. It was tried with gun manufacturers with less success. The same thing. A gun manufacturer knows that people are going to be shot in 7-Elevens. They're going to be shot at night. People's daughters, people's friends can be shot. The gun manufacturer should pay. It was tried with lead paint. So far not successful. That you made a paint 50 years ago. A kid is eating lead paint. He is sick. Rhode Island shouldn't bear the cost of that, but the paint company should. And it's being tested every day as we sit here with pharmaceuticals for risks that products allegedly create, harms to society that eventually have to be paid for by the government itself. The legal engine to drive it are sometimes theories that will put under it public nuisance. But to the extent anybody learned public nuisance in law school, it's not the one we learned about. The one we learned about had nothing to do with damages. You had an injunction. The one we learned about said that the defendant had to be control of the instrumentality. There's no control in any of these cases of the instrumentality at the time of the particular injury. It's in the hands of somebody else. The one we learned about in law school had causation. This dispenses with it and says, well, under market share or some other theory, we're not going to have to show who harmed the state, who was harmed, in the state. Everything is put in a Cuisinart, and that's what we're going to do. The Supreme Court of Rhode Island, which is neither a pro-plaintiff or pro-defendant court, went through this with great articulation in a lead paint case and showed this extension of public nuisance and anti-risk externalization theory simply wouldn't work in that case, and that we shouldn't stretch the law of nuisance beyond any recognition just to reach a result. Often in these cases, and judges have told me this, the judge does not discuss the very core theory that drives it. He discusses, or she, nuisance all the time, not the externalization theory. But that's the gas in the tank. That's the thing that is there to move the liability forward. Under normal strict liability theories, it doesn't hunt. There's only really one, and that's abnormally dangerous activities. But that's very few activities that are completely unnatural to the risk in which they are placed, like explosions and dynamiting, fumigation. It isn't things of this type that a pharmaceutical company may have created a risk for society, or that a gun company did. And product liability is really not strict, as all of you know, and that doesn't get us there. The government anti-externalization of theory would have to just take the restatement, the new one, and toss it, because tort law should not create a duty without wrongdoing. It says that. Tort law should not allow a claim absent specific causation. The restatement says that, not general causation, but specific. And proof of specific causation, it says, is a fundamental policy of tort law. Courts in Rhode Island, New Jersey, Missouri, Illinois agree that causation should not be generalized. So therefore, they would draw the line on risk distribution, externalization theory based on causation. And the restatement is clear that government spending alone cannot be regarded as a predicate for tort law. But that is at the heart of what Mr. Scruggs, who I have great respect for, and others who are suggesting this theory say. If government pays, that creates a duty. But you can search all of the restatement, most of the case books, including my own, and it's not there. But it's very tempting. Think about it. Should any company be able to do this? But if you press the theory, it's down a little bit, but last week every TV show was talking about swine flu. And our vice president had some interesting things to say about getting on a plane. And I was thinking, as this fine man, who I testified before about 12 times, but I never had to answer a question, just sit there, have a good rear end, and you're fine. Suggested that you don't go on a plane. I just got off one. Well, under externalization theory, or anti-externalization theory, the plane, you were in it, you got sick, that creates a cost. If somehow that cost is on the public, then the plane company is liable. A knife manufacturer is liable for OG. I mean, it cannot really work, a beer manufacturer for all sorts of things, I guess. It just will not work in the context of all tort law. Now, sometimes I believe, if I were a legislator, I would vote to have a company pay for certain things that it did, for costs that it would render on society. Maybe a gas company, maybe an auto company should bear some responsibility. It's a legislative issue. But it's not one to be founded in a court decision simply on this cost theory. There are cases brought right now in California under that theory. But that is a duty extension that, to me, is one we're going to face, and everyone in this room is going to face in the next 10 years or so. It's very virulent. It's got a sort of a surface appeal to it, and it's going to come back. All I ask you to do is recognize it and see its fallacies. And we have a very good article. It's long. It's the only one ever written about this theory to show where the line should be drawn. A second duty, and it may have been discussed here, is to protect third parties against conduct of persons who consume pharmaceuticals. The basic theory is that if somehow there is a failure to warn, allegedly a patient takes the drug, he goes out and does something, drives a car, falls asleep, hits the plaintiff, that the duty should extend not merely to the patient who took the drug, but to the person who was injured by the driver. Now, it is not so far-fetched. The Supreme Court of Massachusetts used just such a theory, it's in my outline, in imposing liability on a physician, and said, the person said, well, the physician didn't warn me that I was going to get sleepy. The person injured another in a car seriously, fell asleep at the wheel. The lawsuit is brought. Those of you who have ever worked plaintiff's law know that when you have an auto case and the defendant who did it is judgment proof or doesn't have a lot of insurance, you use everything in your imagination to find another deep pocket defendant. And this plaintiff's lawyer said, why not sue the doctor? And the Supreme Court, Judicial Court of Massachusetts, in a split, I think it was 4-3, held there was such a duty. Wow, if you were a doctor in Massachusetts, now you don't have to worry about being sued by your patient, but anybody your patient may injure, because the patient may not remember exactly what you told him, especially if he has somebody coming at him. There's a motivation there to possibly not remember as well as one should. And all of a sudden, the physician is in the hoop. And if I were writing medical liability insurance in Massachusetts right now, I would have my green eye shade on about where I'm going to set those rates. No discussion of that in the majority opinion. But the consequences of that ruling, I think, are very, very dangerous. But it's the same theory that was then applied to pharmaceuticals. We filed an amicus brief for the Supreme Judicial Court of Maryland in Gordine. Lilly, drug. Allegation, Lilly didn't fully warn the doctor didn't fully warn the patient, this patient fell asleep, and the argument was that Lilly should be liable. For failure to warn the patient with a consequence of bringing in a plaintiff with whom Lilly never dealt at all. The court has a very articulate opinion. It sets forth the policy reasons as to why this is improper. And a very good discussion, and I listened to Valerie carefully, about why foreseeability cannot be the engine of duty. With hindsight and an injured person in front of you, almost anything is foreseeable. And the new restatement, I think, does a good job in showing that that cannot drive duty alone. Yeah, it's foreseeable. If perhaps there's not a warning that's proper, that the patient may not get the warning, the patient may do something and hurt a third party. It creates an indeterminate number of plaintiffs, and of course, as far as the learned intermediary rule, assuming you have it in your state, this would say it applies if the patient is injured, but not if somebody who's hit by a car is injured. So it was nicely rejected. I don't think we need additional deterrence against drug companies. Some people may think so, but there's quite a bit out there. The third duty is of a name brand pharmaceutical company for wrongful acts of a manufacturer of generic drugs. And this was very, very nicely discussed. But I thought about this because in law school I remember the person from the other planet test. Now, the person from the other planet test, some of you may remember it, is if an intelligent being came here from another planet, can you explain something to him in 5 minutes? Can you explain to them why a competitor who has made a product should be subject, that you should be subject to liability for what your competitor does, simply because he did the same thing as you? I know that doesn't deal with legal theory and the niceties of what both Bert and Valerie talked about, but it does maybe explain, and I heard the Supreme Court of Louisiana went along with this, why most courts have rejected this approach. The consequences here create, as Bert articulated so well, an almost unlimited number of plaintiffs, and I don't think deterrence is needed. The public policy reasons were well stated by him, and I'm not going to just repeat or reprise what Bert did so well and what Valerie presented on the other side. The final duty was discussed the other day, and that is whether the learned intermediary rule should be thrown away. My friends on the Supreme Court of West Virginia did just that. They're the only court in the nation to have done so. The risks with pharmaceuticals are really not understandable by ordinary folks, except in very limited cases, and it's got to be very limited, where a plaintiff's sole reliance of taking this drug is based on some ad, no intervention by a doctor, which is almost impossible, except in mass distribution of drugs, which has an exception to this rule already. It's still a good rule. The person who's the traffic cop on pharmaceuticals should be the doctor. Let me conclude with this. I was thinking about all these cases, and we're working now on, I think it's the 12th edition of our casebook, to try to pull together just some things to think about when somebody is coming to you, Judge, to extend duty. And there's just a few questions you can ask yourself, and they're all in my outline. If the bedrock of the expansion is foreseeability, that's a concept that's been rejected by the new restatement and most courts. It doesn't have sound logic and public policy. If the real magnet for extension is the search for a deep pocket, as it was in Gordine, at least if I had the honor of being a judge, I would reject it. If deep pocket is about on the bottom, that's not really a place to make law. Is there a true fault-based theory that creates an underpinning for extension? Is there a true fault-based theory that creates an underpinning for the extension? I'd give consideration to that, because that may mean it is right to extend the duty. Is the duty extension based on a true relationship with the plaintiff, or does it violate Justice Cardozo's bedrock principle that duty imports relation? And that is where foreseeability needs some guard. A relationship. You all remember Palsgraf. The railroad was not liable to the world. There was no relationship between, from his point of view, the woman far down by the scale and the railroad itself. And duty imports relation. It is not a relation with a consumer of the product. And if you throw that out, duty just becomes an open door. And finally, is it really necessary to meet the goals of deterrence and just compensation, or is it an expansion that ignores both factors, as well as the fact that any defendant's assets have limits? I don't care who it is, especially today, any defendant, even though they may be perceived as a deep pocket, has limits. I'm told stop. Can I do a quick Spectre, or is that, what would you say?
Senator, please comment on how things have been going in your career lately.
What I would like to do, I'd like this opportunity, Henry, to come before this august forum in the future and argue both sides, so I would have a full half hour then. Thank you very much.